Welcome to The Explainer. Today, we are unpacking a seriously gripping legal tug-of-war. We're talking about money, constitutional rights, and the justice system itself. We're going to dissect a real-world legal drama step by step, right where criminal law and harsh financial realities collide in a pretty spectacular way.
Think about this for a second. If the government freezes your bank account, can you still use that money to pay your high-priced defense lawyers? It's an incredibly relatable, high-stakes dilemma, and it sits right at the heart of today's explainer. I mean, imagine being accused of a massive crime. Your assets are entirely locked down by the state, but you still desperately need to hire legal representation to defend yourself. Where does the money come from? And even wilder, what happens if you already owe that frozen money to someone else?
Okay, let's dive right into this. We're breaking down a complex 28-page constitutional court judgment from South Africa, the 2006 case of Fraser versus ABSA Bank. We'll start with the millionaire in the bank, explore how assets are frozen under the law, unpack the central conflict of who actually gets paid, see how the lower courts completely disagreed, and finally, look at how the highest court in the land stepped in to resolve the whole shebang.
So, Part 1, the millionaire and the bank. Now, what's really interesting about this timeline is how we actually get to the freeze. We've got two main characters. Trent Gore Fraser, a businessman with a, let's call it, dubious financial history, and ABSA Bank, a very frustrated creditor. Back in July 2000, ABSA gets a default judgment against Fraser for an unpaid debt. The very next year, Fraser inherits over 1.8 million rand. But instead of paying off his debt, in 2002, he buys real estate and hides the assets in a corporation under his fiance's name. It's a classic evasion tactic, right? Well, fast forward to November 2003, Fraser is arrested for racketeering and drug trafficking. And by November 2004, the state officially steps in and freezes his assets.
And by December 2004, that original debt Fraser owed to ABSA Bank had ballooned with interest to exactly 1,028,214 rand and 25 cents. I really want to emphasize this specific number because it makes the financial stakes so tangible. This is a massive, unsecured debt. ABSA has been chasing this money for years, and literally right when it looks like they might finally recover it, the state swoops in and freezes everything Fraser owns.
Which brings us to Part 2, freezing assets under POCA.
So how exactly did the government lock up his money? They used the Prevention of Organized Crime Act, commonly known as POCA. Under POCA, the state can apply for a restraint order. This is a legal mechanism that places an accused person's property completely beyond their control. The assets are handed over to a curator bonus, which is basically just a state-appointed guardian, pending the outcome of the criminal trial. The main goal here is simple, and honestly pretty logical: to ensure that criminals don't benefit from the proceeds of their crimes. If you're convicted, the state wants to make absolutely sure the money is still sitting there, ready to be confiscated.
But here is where things get really messy. Think of Fraser's frozen assets as a frozen pie. It's just one finite pile of money, but suddenly there are way too many hungry mouths trying to grab a bite. The state wants the pie preserved for potential confiscation later on. Fraser's defense lawyers want a big slice of the pie to fund his very expensive racketeering trial, and ABSA Bank is standing right there saying, hey, wait a minute, that pie was bought with money owed to us. If Fraser is allowed to just eat the pie to pay his legal team, ABSA Bank starves.
Let's move to the next part and see how this builds. Part 3, the conflict. Who gets paid?
This massive clash actually happens because POCA has a built-in loophole. Section 26(6) of the Act allows an accused person to apply to the High Court for an allowance. Basically, they can ask to use their frozen assets to pay for reasonable living and legal expenses. Well, the second Fraser applied for this allowance, ABSA immediately intervened to try and block him. To understand why ABSA was so desperate, you have to understand their legal status. ABSA is what's known as a concurrent creditor. That means they have an unsecured claim. They enjoy absolutely no legal preference or priority under insolvency law over other debts. And because of the restraint order, they can't execute their judgment debt either. They are entirely stuck. They're just watching from the sidelines as Fraser attempts to drain the exact funds they are trying to recover, all to pay for his own criminal defense.
So we arrive at this fundamental ethical and legal dilemma. Should an accused criminal be allowed to use money he legally owes to a bank to fund his legal defense? It's a tough one, right? On one hand, everyone has a right to a fair trial, and that absolutely includes legal representation. But on the other hand, is it really justice if the creditor is left with absolutely nothing just because the accused spent the money they owed on lawyers?
And that brings us to Part 4. The lower courts disagree. I'm not kidding when I say this exact dilemma caused massive whiplash within the South African legal system. As the case worked its way up through the courts, different judges came to completely opposite conclusions. First, the High Court sided entirely with Fraser. The judge ruled that the South African Constitution guarantees a right to a fair trial under Section 35(3), period. The High Court literally said that the claims of concurrent creditors like ABSA must be completely left out of account, and they dismissed ABSA's application to intervene. But then, ABSA appealed to the Supreme Court of Appeal, and they flipped the script completely. The Supreme Court of Appeal ruled in favor of ABSA. They stated that a creditor who had pursued a claim and actually obtained a judgment couldn't just be ignored simply because the debtor's assets were restrained by the state.
And this brilliantly illustrates just how far the Supreme Court of Appeal went. They didn't just let ABSA intervene. They practically guaranteed ABSA's money. The court ordered that Fraser's assets be ring-fenced. They ruled that Fraser could not touch a single cent of his frozen assets for legal fees if it meant the total pool of money dropped below the roughly 1 million rand he owed to ABSA. So effectively, the creditor's claim was suddenly elevated right above the accused's right to fund his own legal defense.
Which sets the stage for the final showdown. Part 5. The Constitutional Court steps in. So with two courts issuing diametrically opposed rulings, the tension is at an absolute breaking point. Fraser takes the case to the ultimate tiebreaker, Justice van der Westhuizen and the Constitutional Court of South Africa. The Constitutional Court looked at the rulings and essentially said, well, both lower courts got it partially wrong. Instead, they provided a much more nuanced resolution. They completely rejected the High Court's rigid rule that creditors can never intervene, but they also rejected the Supreme Court of Appeal's rigid rule that a concurrent creditor's claim automatically takes priority over legal expenses. The new precedent: creditors absolutely have standing to intervene and be heard, but they don't automatically win. There is no one-size-fits-all rule here.
So the crucial point is how judges are actually supposed to decide who gets the money going forward. The Constitutional Court grounded this abstract law in practical reality by outlining a very careful balancing act. Now, when an accused asks for legal fees from frozen assets and a creditor objects, judges have to weigh specific factors. How serious and complex are the criminal charges? What's the total value of the frozen assets? And critically, what is the conduct of the defendant? Have they been honest? Or, have they been actively trying to cheat the system?
Applying these factors to Trent Gore Fraser, the Constitutional Court finally delivered its verdict. And honestly, Fraser's own deceptive conduct came right back to haunt him. The court noted that he had deliberately hidden his inheritance in that corporation under his fiance's name specifically to evade ABSA. If he hadn't done that, ABSA would have easily recovered their money long before the state ever froze his assets. Therefore, the court ruled impartially that Fraser shouldn't be allowed to benefit unduly from the restraint order, especially to the severe prejudice of a creditor he had actively tried to defraud.
Justice van der Westhuizen perfectly summarized the delicate legal and moral tightrope the justice system has to walk here. He wrote, "The High Court should seek as best as possible to ensure that a defendant neither benefits unduly from the terms of a restraint order, nor is prejudiced as far as reasonable legal expenses are concerned. It is just this continuous, difficult balancing act between respecting core constitutional rights and ensuring basic financial fairness."
Which leaves us with a final, provocative thought to consider. If a suspect's right to a legal defense is treated as absolute, who ultimately pays the price when the money runs out? Is it the state? Is it the victims of the crime? Or like in this case, is it a creditor who is simply trying to collect what they are legally owed? It really challenges us to look closely at the real-world financial realities operating right behind our most fundamental constitutional rights. We hope this deep dive helped clarify the complex mechanics of asset forfeiture and constitutional law. Thank you for joining us on this explainer, and we can't wait to unpack more fascinating topics with you soon.